just because a case is sealed doesn't mean a motion can't be filed to unseal a case. Okay, so there's a way to undo what has been done. Even if the case has been sealed, you can still go to the clerk's office to view your own cases. You'll have the docket numbers, or if all you know is the name and can't remember the docket number, as long as it's your case, the clerk will be able to look it up. For the case to get sealed, a petition has to start the process. This was one of my biggest fears when I first heard of eviction sealing. It's like, oh no, this is going to be an automatic process. As soon as the case is done, records will be sealed and we'll never be able to look them up. That's not how this is going to work. Hey, what's up all of my real estate peeps? This is Brian Lucier with another episode of the Why Not Real Estate Podcast Golden Nugget, where we will take a tip, tactic, or technique and unpack it for you as a real estate investor that you can use in your tool belt to make you a better and more successful real estate entrepreneur, landlord, property manager, real estate investor. So all my peeps, rock stars, realtors, entrepreneurs, I have been waiting a long time to do this one, but I had to wait for it to happen. So what are we going to talk about today and how does it affect you? May 5th, Mass General Law 239, subsection 16, eviction sealing came into effect. So this past week, I believe it was on the 15th, I was on a Zoom call taking copious notes that I'm going to share with you now. What is eviction sealing? How does it work? What can you do? What can you not do? And let's jump right in. First, I want to thank Mass Landlords and all of the staff, including Chief Justice Diane Haran. She's been on the bench for many of the cases that I've had heard, and I think she's just a wonderful and fair person. I'm happy to see her in the role of Chief Justice. Thank you, Your Honorable Chief Justice Haran. So let's dive right in. And I'm going to be reading a lot of this because I'm going to make sure I get it perfect. So just bear with me and let's roll in and get started. May 5th, 2025, eviction sealing law went into effect. Pleasantly surprised but cautiously optimistic, the courts have been able to keep up with the requests in the case petitions and have been manageable up to this point in time. When everybody thought this was going to roll out, they said, oh no, there's going to be a flood. But it wasn't. The petitions are being processed. There is no crisis, no tsunami of case overloads in the court. Some divisions are diverse in how they're going to be handling these petition requests. Some may schedule, they come in and they deal with them. Others may stack them up and have a dedicated session for petition court hearings. They'll have a dedicated session for doing that. The different divisions of housing court in Massachusetts are going to deal with that differently basing on their staff and how many requests they get. You're going to see some differences in the divisions on how they handle this, and that's okay. So there is a shifting horizon since the pandemic for changes in these laws and policies. So we really need to keep a pulse on topics like this to better navigate tenant-landlord laws, and for me personally, to get the word out there for you, all of my real estate investors. So a little start to get us rolling here. E-delivery, you may or may not know about this. This is something that attorneys have been able to do for quite some time now. This will allow an attorney to receive selected documents and updates about their court proceedings to their email instead of their postal mail. This speeds up the program. Well, I have some good news. There is a pilot program currently being released in the Central Court Division and the Northeast Court Division, which means a property manager like myself, a landlord like yourself, if you have a docket, summary process, or civil court case in Central Court or Northeast court divisions, you now will be able to sign up for e-delivery. So what does that mean? It means all your notifications will now come to you through email. So you can consider registering for e-delivery service on the mass.gov website. You'll be able to find it. Or you could go into the clerk's office in Worcester and request to do it there. However, mind you, once you sign up for e-delivery, you will no longer receive postal mail. So keep an eye on your inbox. That's going to be critical for you. So as of April 2024, housing court images of documents are now visible on masscourt.org, also known as Access Mass Courts court cases. So you can get on through masscourts.org, click around a little bit and actually see the documents now. This has been live for just about a year, April 2024. This will include civil cases, small claims court, summary process, and supplementary process cases. Some filings are not available, such as medical or some affidavits to protect where people's names have to be redacted to protect them for their privacy. Okay, so that's e-delivery. That's something that's available now. We, the common folk, can use it. You sign up, Central or Northeast Division. So let's get into eviction sealing, what this is and how it means. So for an eviction sealing to happen, somebody needs to fill out a petition. When I first heard about all this, I thought, oh no, it's going to be automatic. There's going to be a flood, a tsunami of all these sealed cases. How are we going to screen people? That's not how this is going to work. So on the MassGov site, there is a guided interview that has been created to assist the petitioners to fill out the form to allow the court record to be sealed. It's a request. It's a petition request that a petitioner can fill out and send to the court. This is not to be taken as legal advice. I'm not an attorney and I don't play one on TV. The guided interview is just a series of questions to help guide them through the process of filling out the form. The platform is free to use. There's also, like I said, the page on MassGov that was created to address the process of eviction sealing and provide the required forms needed to start the process. Part of the process of the guided tour on mass.gov will allow the petitioner to directly e-file directly from that guided interview platform online. The petitioners, once they do it, they can send it and it goes directly to the clerk's office, or the petitioners, if they choose, can download a copy of the completed petition being filed, or they could do both. Wrap in the Affordable Homes Act. This was signed by the governor August 6th in 2024 and added a new chapter 16 to the General Law 239, providing for the sealing of residential summary process court records. So that's when all this happened. The Affordable Homes Act added subsection 16, Affordable Homes Act, Mass General Law 239. That's where you're going to be able to find all the information to read up on the statute and how it affects you. I'm just doing a high-level 30,000-foot overview right now based off what I heard on that Zoom call. So this law requires the use of the forms provided by the court to petition to seal an eviction of court record. The petition must be signed by the petitioner under the pains of penalties and perjury and filed with the same court division as the action seeking to be sealed. So if my case was in Central Housing Court, I'm going to file the petition with Central Housing Court. These are filed as part of the existing records and not as a separate new case. So if I had docket number ABC 123, I'm going to file the petition under docket ABC 123. If the trial has heard in separate courts in lieu of being transferred, for whatever reason, medical reason, or somebody couldn't make it to Leominster, they wanted to be heard in Worcester, or vice versa, then both of these courts would need to receive the petition, and they may have different dockets. I'm not sure. That, again, is going to be decided by each court division when it transfers over. So the petition must be filed in each court division that the court case was heard to seal that separate associated docket numbers. All petitions will be reviewed by a judge. Once a petition gets filed, it is accepted and processed by the clerk's office. Then it goes to a judge to decide or put it on for hearing if necessary. If there is a hearing scheduled, the court will send notice to all parties relevant to that action. Once a decision on the petition enters, the notice of that order will be sent to all parties involved in that case. So if you haven't signed up for e-delivery, it's going to come U.S. Postal Service. If you are signed up for e-delivery, check your email. That's how you're going to find out. The timetable for processing depends on the court division and may be ruled on during a dedicated record sealing session. It depends on volume, right? If there are just a few, they may do a one-off and just take care of it that way. If they get loaded with a bunch of them, they'll probably schedule a session and call Worcester Housing Court and find out how your district is going to handle them. They're all going to approach it differently based on volume and resources. So if no fault eviction files a petition to be sealed, or let me start over. In a no fault eviction, a petition to seal may be filed immediately upon the conclusion of that action in court and the exhaustion of all rights of appeal with the notice to be sent to other side. It is the responsibility of the petitioner to provide notice to all other parties named in that petition. The courts may process these petitions if no objection is filed within 7 days. Don't freak out. There's systems in place. So again, in a no-fault petition, somebody's getting evicted for whatever reason, they're just not going to renew because they're going to remodel, no fault. As soon as that's done, if the petitioner wants to start to do eviction sealing, they can file it immediately. In a non-payment of rent eviction, where the judgment has not been satisfied, which means the defendant usually still owes money to the landlord, the case may be sealed after 4 years from the conclusion of the action, including exhaustion of all rights of appeal where other statutory requirements must be met. This includes any intervening lessor actions brought against the petitioner at that time. So if this, for whatever reason, the petitioner goes to seal this record and they still owe money, there's a very good chance that the other side will be able to object and keep this court record open while there's still a monetary judgment. So the statute defines a lessor-leaseor action as any civil action brought against the owner, manager, or lessor of a residential premises by the tenant or occupant on the premises for any breach of the agreement, the rental agreement, or any such violation of the law for occupancy, habitability. Section 16 does not limit the 20-year time period for executions, money orders, standing to collect outstanding money judgment. So this can go back and forth for up to 4 years. There's a 4-year window for that to be sealed for a non-payment of rent eviction. Okay? Petitions for sealing of record on non-payment of rent where monetary judgment has been satisfied. The tenant comes in, writes a check to the landlord, everything's done. These may be filed immediately upon the receipt of notice of satisfaction on the judgment. So if you're a tenant and you've had to pay off the landlord, request that letter for the satisfaction of the judgment. You can file that with your petition and seal the record. The statute requires parties to file notices of satisfaction, if somebody has paid me off, within 14 days after the satisfaction of judgment, after I get the check, if the eviction cases were brought solely for non-payment of rent. Where no satisfaction of judgment was filed, petitioners may file petition for judgment or agreement to be deemed satisfied on trial on a trial court supplied form. You'd have to submit a form for that. The court may act on those petitions if no objection is filed in 7 days. But again, don't fret, don't dismay. There are fail-safes built into this system. So don't think, okay, 7 days, it got closed out, you're screwed. That's not how this works. Let's continue. So the fault evictions may be sealed after 7 years from the conclusion of the action, including meeting all the exhaustion rights of appeal and other statutory requirements have been met, and may be processed if no objection has been processed in 7 days. So it's built into both of these. There's the 7-day window to file an objection where you can say, hey, I don't want this record sealed because, and that's all going to be up to the judge, judicial discretion. You're going to hear that throughout this. So eviction actions brought pursuant to General Law 139, subsection 19, that's a different law, may be sealed after 7 years also. From the conclusion of the action, including the exhaustion of all rights of appeal and where the statutory requirements have been met. In these cases, the court shall schedule hearings unless any eviction, including Section 19 cases that were dismissed or resulted in judgment of favor of the defendant or tenant, may be requested to be sealed immediately on the conclusion of the action, including the exhaustion of all rights of appeal without notice to the parties. So under a Mass General Law 139, subsection 19 eviction, if the defendant, tenant wins, they can file for court sealing, file court sealing, you know what I'm trying to say, immediately, without notice to the other parties. Such petitions may be processed without a hearing. Done. Sealed eviction court records may be made available in certain situations upon motion and for good cause shown, including the balance of certain statutory defined interests, including for a person or for their representative who is a party to the sealed action. They may request for the release of the action on a court-provided form. So if I've got a sealed record, I can still go into the court and request that record. That's okay. Generally, landlords have only 7 days to object to petitions under the statute. Now, if there's snail mail involved or however it goes, my dog ate the mail or I was on vacation, whatever it is, the trial court has developed a generic objection form that's on mass.gov as well, which may be used as the petition to seal or petition to deem judgment as satisfied. In terms of other potentially relevant information, in cases of multiple defendants where only one petition was filed, the judge may order the entire case sealed or just the case of the partially sealed only to the successful petitioner. So if there's 3 people named, only one petition, it could go either way. Depending on judicial discretion, the judge could seal the entire record or they could go for a partial sealing on just the petitioner. The sealing of court records includes the sealing of the FTR audio recordings that they do in session and any information that may result from an e-filing search, the documents online. FTR audio will be sealed upon successful petition. To address e-filing, parties may now only be able to search for eviction cases by docket number. So if I've got a docket that was sealed, I'll no longer be able to look it up by the resident or the defendant's name. I can only look it up by the docket number. So if they're your dockets, you know the numbers, you can look them up and see the status. If they're sealed, you'll know they're sealed. And if you didn't get a petition or notice that there was a petition, you've got a clear case for an objection to reopen that file. We're going to get into that. Finally, all of this and more information can be found on the eviction sealing website that can be found on mass.gov. Other eviction sealing updates. Let's get into this. Under Mass General Law 239, subsection 15, otherwise known as emergency rental assistance pending, a case cannot move forward. If there is emergency assistance pending, that's it. Whether it's a trial, execution, judgment, everything will be put on pause until there has been a decision on the pending rental assistance application. This procedure grew from the pandemic and now today is known as RAFT, Rental Assistance for Families in Transition, or there are a multiple of any other assistance programs or rental assistance being made available that will also qualify as emergency rental assistance. Any of these will put a stop of that trial wherever it is until there's a decision made about that rental assistance. For this law to apply to a case, there has to be a few requirements met to be, first one, exclusively for a non-payment of rent case. You can't go in waiving a RAFT application if it's for a for cause or 139 or other type for cause, not for cause. It can only exclusively be used in this case for a non-payment of rent. If there is rent owed in a case or for no case, this law will not trigger. Again, if there is rent owed in a cause or a case for cause, not non-payment, or for no cause, this will not trigger the pause for this provision. The non-payment of rent has to be due to financial hardship, not just because I didn't feel like paying it. The tenant has to demonstrate proof the application has been started for the emergency rental assistance pause to kick in. Again, all these decisions are based upon judicial discretion. There it is. So also under the Affordable Homes Act, this is new. Under the radar, there are changes and additions to how security deposits can be handled. This act will allow the Executive of Housing and Livable Communities, that's EHALC, I always say LLC, EHALC, that may allow property owners to charge a fee as opposed to a security deposit, which is different and it's going to be treated and handled differently. So EHALC has still yet to supply the rules and regulations as to how all of this is going to play out. This is something that is not in effect yet, but it has been written into the Affordable Homes Act. But it's something to be aware of, and it's on the border horizon, so we're going to keep an eye on this. The Affordable Homes Act does suggest some outlines as to how this fee may be collected, what it can and what it can't be used for. Similarly to a security deposit, it's something that can be used to cover unpaid rent and damage to the unit. There are certain things that you can't use the fee for that you could use a security deposit for, such as to cover unpaid taxes, if that's a clause written into your lease, and a water bill, if that's a clause written into your lease. This unique fee can be collected piecemeal over time, month to month. So that's something different as well. as opposed to entirely upfront. Everything's negotiable with the fee. The total fee cannot equal greater than 1 month's rent, just like a security deposit. If you offer the fee to a resident or a prospective tenant and they prefer the security deposit, you must offer the security deposit and you can't do the fee. It's the renter's choice at that point. This is still being worked out, the details, so stay tuned. The law does not suggest how the fee should be stored or kept, in contrast to the strict regulations for the storage and keeping of a security deposit. The fees also do not mention any penalties the same way that a security deposit law, such as triple damages, that's a huge issue. More to come on this as it develops. So at the end of this whole session, there were some questions and answers, and I'm going to review some of these. So after the filing of the petition, there are 7 days to respond to that petition. Now, for whatever reason, the onus is on the petitioner to send the notice, and they have to sign this under pains and penalties of perjury. But if they don't do it, there's no way for us to know as the property manager or the landlord. So boom, this happens, and it happens without us contesting it. Let's get into this. So again, 7 days to respond to the petition. There is proof of delivery in the summary process. There is no proof of delivery like there is in a summary process. It does not require a constable service. Like I said, the responsibility is on the petitioner to serve notice under pains and penalties of perjury. For an objection to the petition, the other side of the case could say they did not receive it, or how could I have been notified? I was out of the country, or whatever reason. So this is going to be a slippery slope with the burden of proof. There is the mandate, the statute for the 7-day objection period that requires a hearing, but the court's under no obligation to act within 7 days. So this petition may come through, and we don't know how the courts are going to handle these yet. Are they going to do them one-off? Are they going to do every 2 weeks a session for as these come in? We don't know. So the 7 days is a statutory right to file an objection to petition, but that doesn't mean you cannot file an objection after the 7-day period. You can file an objection anytime. So if you do get your notice after the 7 days, don't despair. Just get to court and file your objection that you didn't receive the notice in time, or if there's other reasons. If they still owe you $10,000, I think that's a pretty strong objection. You may find nothing has been acted upon yet, right? You can get this notice in the mail after the 7 days. You go on to mass courts and, hey, my case is still there. That means nothing happened yet. You can always file a motion to unseal an eviction case. Okay, this isn't as scary as it seemed. This puts the burden of proof on the landlord to do service to get the landlord and any legal fees if an entity from lost time of work. So what does that mean? Just like in a summary process, I'm an LLC. So if I'm going to file a court case, I cannot represent myself under, the Hatcher case, right? I can't do myself representation if I'm an entity, a trust, or an LLC or a corporation. I must hire an attorney. Well, again, this puts the burden back on the landlord to do the service. As the landlord, I have to use the attorney or a constable to file my objection. It doesn't seem fair, but that's the way it is. So a quick tip, you could still be seeing your court case on Mass.org, and if so, then the petition probably hasn't been acted upon yet, or the record has not been sealed. If it has been acted on and you still see it, then you probably received a notice order showing the petition to seal has been denied. So there is 3 different flavors here. You've got eviction sealing for eviction non-payment of rent, eviction no cause stated, just the normal 30-day, or an action at fault or a breach. Each is based on the argument made in the initial action and subject to judicial discretion, usually based on the actual notice. So if I served a non-payment of rent, then all the rules and regulations for sealing of eviction records will fall under non-payment of rent. If I used a no cause stated or an at fault or default, then all the rules and regulations under those types of evictions will fall under play for eviction sealings. Again, each is based on the argument made in the initial action, subject to judicial discretion, usually based on the actual notice. On the guided tour to fill out the petition on massgov.org, the petition has the option to both submit directly to the site, through the site to the clerk's office, or download the petition for your records, or you can do both. Attorneys will be required to file petition objections if the original complaint was issued by an entity, LLC, or trust. We already talked about that. This is the same as the court hearing for summary process. The same rules apply for eviction sealing objections and petitions. So you'll need to file and use that attorney or constable, whatever it is. The housing court judges will be applying the Hatcher ruling to these cases. So if you're an LLC, be prepared, you're going to have to hire an attorney or a constable. So just because, now here it is, right? When this came out, everyone was freaking out saying, oh no, eviction sealing, I'll never be able to screen a tenant again. Just because a case is sealed doesn't mean a motion can't be filed to unseal a case. Okay, so there's a way to undo what has been done. Even if the case has been sealed, you can still go to the clerk's office to view your own cases. You'll have the docket numbers, or if all you know is the name and can't remember the docket number, as long as it's your case, the clerk will be able to look it up. For the case to get sealed, a petition has to start the process. This was one of my biggest fears when I first heard of eviction sealing. It's like, oh no, this is going to be an automatic process. As soon as the case is done, records will be sealed and we'll never be able to look them up. That's not how this is going to work. The petitioner must go on, file the court form, file the petition. There's a 7-day period to file an objection. And even if that gets missed, at any point in time, you can file the objection. There's a 4-year window to file for record sealing for non-payment of rent. There's a 7-year window to file record sealing for the other types, no fault, for breach, for cause, 7 years. And again, if it's sealed, you can always file a motion to open it back up or to review the case. Let's talk about raft a little bit, because this came into play at the end, the question and answers, and thankfully I was able to get one of mine answered. So what if the defendant in a summary process action who meets the eligibility for assistance requesting a stay, they say, hey, I've got the raft application, let's kick this down the road for 2-3 weeks. What if their assistance for requesting the stay and files a raft application fully knowing that they have exceeding their apportioned assistance? What does that mean, right? So the defendant says, hey, I've got a raft application and they've already paid my $7,000 this year, but I owe $5,000. But I'm going to file for the raft application anyways, just to file the stay and get this kicked down the road for a couple more weeks. What do we do? Well, if the defendant has exceeded the amount of the assistance or cannot come up with the balance after the assistance has been paid, then we can request that the stay be denied. And again, this is all going to be based on judicial discretion. So if the raft application has exceeded their $7,000, but if there's A, B, C, other rental assistance programs, that depends on the judge's discretion if they're going to allow the stay or just say, no, it's time to go. So this was my question. If we're presented with raft assistance and the renter we know still will not qualify to pay the actual rent after receiving the raft, my question was, can we deny the raft, and I'll tell you why in a second, and suggest the renter use their assistance to obtain suitable housing elsewhere? And this has happened a few times. We've had a case where the tenant came in, we say, look, we know even after you spend your $7,000, you're not going to be able to pay the rent that we need to pay to the landlord, and we're going to be right back here in court to evict you, and this time you won't have the raft. We could work with you, waive fees, waive late rents, whatever, if you choose to use this raft money, first, last, and security, to move to another apartment that you can afford. Sometimes it works, sometimes it's different. It all depends on the court, all depends on arbitration, all depends on the decision of a judge. So again, knowing we will deplete their funds and probably be back in court as soon as they cannot produce the rent, that might be an option. So the answer was very good. The answer was, don't do that. There's a huge risk because of judicial discretion, and do not do this. If there's a rental application on the table, if it doesn't work in an arbitration, then accept the raft application. Never deny the raft application. Always go through the process. This is an obligation we must participate in, even though we have the best intentions to help the resident. This is a negotiation topic to discuss while both parties in arbitration. In arbitration, you can discuss anything reasonable, where in a trial or court hearing situation, you may not be able to. So proceed with caution. So that was the final word on the raft. If the application is on the table, accept it. There may be other things on the table as well. So definitely, this was one I've been waiting to share with you for a while. We finally got the information from the courts. I digested it all. I put together this script. I read the whole script to you. Please, please, please save this. Share it with other landlords you know. Eviction sealing is real. This is how it works. This is how you can work with it. And what do we do as landlords, right? The law changes, so we educate ourselves. We figure out a strategy, and we pivot. What can we do now that the law says this? Well, this is definitely a little bit of a blueprint for all of my landlords out there, property managers, on how you can navigate the waters of eviction court record sealing. This is definitely a good one. I hope you enjoyed it. If you didn't take notes, that's okay. It's a recording. You can rewind it, replay it. If you go out onto the podcast, you can listen to it while you're driving in your truck to and from work or job sites. So there it is. All of my real estate peeps, my real estate rock stars, entrepreneurs, ladies and gentlemen, there it is. Real estate eviction record sealing. This is Brian Lucier from the Why Not Real Estate Podcast, Yellow Golden Nugget, sealing off, and we'll see you on the next one.